Mark Jensen, 2002 CF 314. The appearances are the same. The jury is not in the courtroom. Prior to taking our lunch break, the issue was brought up of whether the defendant was going to testify or not. I'll ask Attorney Krause, this is the appropriate time in the trial for that decision to be made, correct?
Correct.
Okay. And is the defendant ready to answer the questions I'm going to ask him?
He is.
All right. Mr. Jensen, I'm going to ask you some questions. Can you hear me?
Yes, I can.
All right. First of all, do you understand that you have a constitutional right to testify?
I do.
And do you understand that you have a constitutional right not to testify?
I do also.
And do you understand that the decision whether to testify is for you to make?
I do.
Has anyone made any threats or promises to you to influence your decision?
Not in any manner.
Have you discussed your decision whether or not to testify with your lawyer
I have.
or your three lawyers?
I have.
All right. Have you made a decision?
I have.
And what is your decision?
I elect not to testify.
You're not going to testify?
Correct.
All right. And then, Ms. Krause, have you had a sufficient opportunity to thoroughly discuss this case and a decision whether to testify with the defendant?
I have.
Are you satisfied the defendant is making this decision knowingly, intelligently, and voluntarily?
I am.
Do you want to add anything for the record?
No, Judge, thank you.
All right. The record should reflect we did indicate to the defendant his right to testify, his right not to testify. He's discussed his decision with his attorneys. He's made his decision on his own, and he has indicated to the court that he wishes not to testify. And based upon that, I'm going to make a finding that the defendant has knowingly, voluntarily, and intelligently waived his right to testify without the jury being in the courtroom, and the record should reflect that.